The case of DPP v. Smith 2006 is important as it extended the meaning of bodily harm in the Offences Against the Person Act 1861. The defendant's ex-girlfriend went round to his house whilst he was asleep in bed. She went up to his bedroom and woke him up. He pushed her down onto the bed, sat on top of her and cut off her hair, which was in a ponytail. He did not physically cause any harm to her, other than the cutting of the hair. She sustained no bruises, scratches or cuts. Whilst she was emotionally upset and distressed by the experience, there was no evidence or suggestion of psychiatric injury. The defendant was charged with assault occasioning actual bodily harm under Section 47 of the Offences Against the Person Act 1861. The magistrates held that there was no case to answer in relation to the charge under Section 47, as cutting of hair itself did not constitute actual bodily harm. The prosecution appealed to the Divisional Court of the Queen's Bench Division. The Divisional Court held that the cutting of hair did amount to actual bodily harm. Sir Igor Judge, President of the Queen's Bench Division, stated, "Recent authority shows that evidence of external bodily injury, or a break-in or bruise to the surface of the skin, is not required." Chan Fook established that actual bodily harm was not limited to harm to the skin, flesh and bones of the victim. It applies to all parts of the body, including the victim's organs, his nervous system and his brain. Physical pain consequent on an assault is not a necessary ingredient of this offense. In my judgment, whether it is alive beneath the surface of the skin or dead tissue above the surface of the skin, the hair is an attribute and part of the human body. He continued, "It is intrinsic to each individual and to the identity of each individual. I note that an individual's hair is relevant to his or her autonomy. Some regard it as their crowning glory. Even if, medically and scientifically speaking, the hair above the surface of the scalp is no more than dead tissue, it remains part of the body and is attached to it. While it is so attached, in my judgment it falls within the meaning of bodily, in the phrase, actual bodily harm." Cresswell J. stated, "The body, for the purposes of the word bodily, in Section 47 of the 1861 Act, includes all parts of the body, including the hairs upon the scalp. To a woman, her hair is a vitally important part of her body. Where a significant portion of a woman's hair is cut off without her consent, this is a serious matter amounting to actual, not trivial or insignificant, bodily harm." In summary, DPP v. Smith 2006 established that actual bodily harm could include the cutting of hair and that pain was not a requirement of the offense. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.